If you are a green card holder living in the United States right now, you need to stop everything you are doing and pay close attention to what I am about to share with you. A significant new immigration law has just been passed, and the implications for lawful permanent residents are substantial. This is not a rumor. This is not speculation from social media. This is real, verified information that could directly affect your ability to maintain your green card, travel internationally, and eventually become a United States citizen. I am James, and I have been working as a senior immigration professional for the past 6 years. Through this channel, Immigration News Today, I have made it my mission to bring you accurate, timely, and practical information that you can actually use to protect your immigration status and your future in this country. So please, stay with me until the very end of this video, because what I am about to explain could be one of the most important updates you hear this year. Now, before we dive into the specifics of what just happened, I want to take a moment to acknowledge the emotions many of you are probably feeling right now. When you see a headline that says, "A new immigration law has been passed and it affects green card holders," your heart probably skips a beat. You might feel anxious, confused, or even scared, and I completely understand those feelings. The immigration system in the United States is complex, and when changes happen, it can feel like the ground is shifting beneath your feet. But I want you to know that my goal today is not to scare you. My goal is to inform you, to empower you, and to give you the tools and knowledge you need to navigate these changes with confidence. So take a deep breath and let us work through this together. As of date, new legislation has been signed into law that introduces significant changes to how the United States government monitors, evaluates, and enforces the conditions of lawful permanent residency. This law, which has been the subject of intense debate in Congress over the past several months, represents one of the most substantial shifts in green card policy we have seen in years. The legislation was covered extensively by major news outlets including Reuters, the Associated Press, the New York Times, and the Wall Street Journal, and it has been confirmed through official statements from the Department of Homeland Security and United States Citizenship and Immigration Services. What this means for you, as a green card holder, is that there are new requirements, new obligations, and new risks that you need to be aware of starting immediately. Let me break down the key provisions of this new law in a way that is clear and easy to understand. The first major change relates to the continuous residence and physical presence requirements for green card holders. Under the previous rules, lawful permanent residents were expected to maintain the United States as their primary home, but the enforcement of this requirement was relatively flexible. Green card holders could travel abroad for extended periods, sometimes up to a year, without automatically losing their status, although prolonged absences could raise questions during the naturalization process. Under the new law, however, the rules have become significantly stricter. The legislation introduces a new tracking system that will monitor the travel patterns of all lawful permanent residents. If you leave the United States for more than 6 months without obtaining a re-entry permit in advance, you will now be subject to automatic review upon your return. This review could include a formal interview with a Customs and Border Protection officer, a request for documentation proving your intent to maintain permanent residence, and in some cases, the initiation of proceedings to determine whether your green card should be revoked. Now, I want to be very clear about something. This does not mean that you cannot travel. It does not mean that you will automatically lose your green card if you leave the country. What it does mean is that the government is paying much closer attention to the travel habits of green card holders. And if you are someone who spends a significant amount of time outside the United States, you need to take proactive steps to protect your status. The most important thing you can do right now is to review your travel history. Look at how much time you have spent outside the United States over the past 5 years. If you have taken trips lasting more than 6 months, or if you have a pattern of spending more time abroad than in the U.S., you may want to consult with a qualified immigration attorney to assess your situation and develop a strategy for maintaining your status under the new rules. The second major provision of this new law relates to the public charge rule. Now, if you have been following immigration news over the past few years, you know that the public charge rule has been one of the most controversial and frequently changing aspects of immigration policy. The basic idea behind the public charge rule is that the United States government wants to ensure that immigrants are self-sufficient and not primarily dependent on government assistance. Under the new legislation, the public charge assessment has been expanded and strengthened for green card holders who are applying for naturalization. This means that when you apply to become a United States citizen, USCIS will now conduct a more thorough review of your financial history, including your use of any public benefits over the past 10 years. If you have received certain types of government assistance, such as cash welfare benefits, supplemental security income, or long-term institutional care funded by Medicaid, this could be considered a negative factor in your citizenship application. I know this might sound alarming, but I want to put it in perspective. The public charge rule has always been part of immigration law, and the vast majority of green card holders who work, pay taxes, and contribute to their communities will not be affected by this provision. The key takeaway here is that if you are planning to apply for citizenship in the near future, you should gather documentation that demonstrates your financial stability and self-sufficiency. This includes tax returns, pay stubs, bank statements, and any other evidence that shows you are supporting yourself and your family without relying primarily on government assistance. If you are concerned about your specific situation, I strongly encourage you to consult with an immigration attorney who can review your case and provide personalized guidance. The third major change introduced by this new law relates to criminal history and good moral character determinations. Under the previous rules, USCIS had discretion in evaluating how certain criminal offenses would affect a green card holder's eligibility for naturalization or their risk of deportation. The new law, however, introduces more rigid standards and mandatory consequences for certain types of offenses. Specifically, the legislation expands the list of crimes that are considered bars to good moral character, which is a requirement for naturalization. It also introduces new grounds for deportability that apply to green card holders who have been convicted of certain offenses, even if those offenses occurred many years ago and even if the individual has since rehabilitated and become a contributing member of society. Now, I want to be very careful here because this is a sensitive topic, and the specifics of how this provision will be applied are still being clarified by USCIS and the immigration courts. What I can tell you is this. If you have any criminal history whatsoever, even if it is a minor offense from many years ago, you should not apply for citizenship or travel internationally without first consulting with an immigration attorney. The consequences of triggering a review of your criminal history can be severe, including the potential loss of your green card and removal from the United States. This is not a situation where you want to take chances or make assumptions. Get professional guidance before you take any action that could put your status at risk. The fourth significant provision of this new law involves enhanced verification and documentation requirements. Under the new rules, all green card holders are now required to ensure that their information on file with USCIS is accurate and up-to-date. This includes your current address, your employment status, and any changes to your personal circumstances such as marriage, divorce, or the birth of children. The legislation introduces penalties for failure to update your information within specified timeframes. If you move to a new address, for example, you are now required to notify USCIS within 10 days, and failure to do so could result in fines or, in extreme cases, be considered a factor in a deportability determination. Additionally, the new law requires green card holders to carry their physical green card with them at all times when they are in the United States. While this requirement has technically existed for many years, enforcement has been inconsistent. Under the new legislation, failure to carry your green card can now result in civil penalties, and repeated violations could be considered evidence of failure to maintain permanent resident status. So, what does all of this mean for you in practical terms? Let me give you some concrete action steps that you can take right now to protect yourself and ensure that you remain in compliance with the new law. First, check your address on file with USCIS. If you have moved at any point in the past and did not update your address, do so immediately using the official USCIS online change of address tool or by filing Form AR11. Second, locate your physical green card and make sure you know where it is at all times. If your green card is expired or will expire soon, begin the renewal process now by filing Form I-90. Do not wait until the last minute, as processing times can vary and you do not want to be caught without a valid card. Third, review your travel history and assess whether you have spent extended periods outside the United States. If you have, consider whether you need to apply for a re-entry permit before any future international travel. Fourth, gather documentation of your financial stability, including tax returns, employment records, and bank statements. This will be useful not only for any naturalization application, but also as evidence of your ties to the United States if you are ever questioned about your intent to maintain permanent residence. Fifth, if you have any criminal history, no matter how minor, consult with an immigration attorney before taking any action that could trigger a review of your case, such as applying for citizenship or traveling internationally. Now, I want to take a moment to address some of the misinformation that is already circulating about this new law. On social media and in some community forums, I have seen claims that green cards are being revoked en masse, that people are being deported without warning, and that all green card holders need to immediately apply for citizenship or risk losing their status. None of this is true. While the new law does introduce stricter requirements and enhanced enforcement, it does not change the fundamental rights of lawful permanent residents. You still have the right to live and work in the United States. You still have the right to travel internationally, subject to certain conditions. And you still have a path to citizenship if you meet the eligibility requirements. What has changed is that the government is now paying closer attention to whether green card holders are meeting their obligations, and there are new consequences for those who do not. This is why it is more important than ever to stay informed, stay compliant, and seek professional guidance when you need it. I also want to address a question that I know many of you are asking, which is whether you should accelerate your plans to apply for citizenship in light of this new law. The answer to that question depends on your individual circumstances. If you are already eligible for naturalization and you have been considering applying, now may be a good time to move forward, as having U.S. citizenship provides a level of security and stability that a green card cannot. However, if you have any issues that could complicate your citizenship application, such as extended absences from the United States, use of public benefits, or a criminal history, you should consult with an attorney before filing. Applying for citizenship when you have potential issues in your background can sometimes trigger consequences that would not have occurred if you had simply maintained your green card. This is a nuanced area of law, and there is no one-size-fits-all answer. As we wrap up this video, I want to remind you of the purpose of Immigration News Today. This channel exists to provide you with accurate, timely, and practical information about U.S. immigration law and policy. My goal is not to scare you or to sensationalize the news. My goal is to empower you with knowledge so that you can make informed decisions and protect your future in this country. Immigration law is constantly evolving, and it is essential that you stay up to date on the changes that affect you. That is why I encourage you to subscribe to this channel if you have not already, and to turn on notifications so that you never miss an important update. If you found this video helpful, please take a moment to like it and share it with friends, family members, and community members who might benefit from this information. Your support helps this channel grow and allows me to continue bringing you the content you need. Before I sign off, I want to leave you with an important disclaimer. The information I have shared in this video is intended for general educational purposes only. It is not legal advice, and it should not be relied upon as a substitute for professional legal counsel. Immigration law is complex, and individual circumstances vary widely. If you have questions about your specific situation, please consult with a licensed immigration attorney or an accredited representative who can provide guidance tailored to your needs. Additionally, please remember that immigration policy can change at any time. And while I have done my best to provide accurate information as of date, you should always verify information with official government sources, including the USCIS website and the Department of Homeland Security. Thank you so much for joining me today. I know that navigating the immigration system can feel overwhelming, especially when major changes like this occur. But I want you to know that you are not alone. There are millions of green card holders across this country who share your concerns and your determination to build a better life. Together, we can stay informed, stay compliant, and protect our futures. My name is James, and this is Immigration News Today. Stay safe, stay informed, and I will see you in the next video. Take care of yourself, and take care of each other.